So we don't have a lot of good news for employees these days when it comes to employment law, unfortunately, but here's one. There's a Supreme Court case called Muldrow versus the city of St. Louis. The title's right up top. So this is actually a 2024 case, but it's starting to trickle down through the lower courts in a good way, and here's why it could be important to you. Hi, I'm Tom Spiggle with the Spiggle Law Firm. We help people who've been fired or afraid that they might be. So in order to bring a claim under Title VII, which is the big federal anti-discrimination law, you have to show something bad happened to you called an adverse employment action. So if you've been fired or something like that or demoted, that's pretty clearly an adverse employment action. But there are a lot of cases where that doesn't happen, and particularly in cases where an employee is transferred. Prior to this case, a lot of courts were saying, if you're transferred but it doesn't affect your title or your salary, that's not really an adverse employment action, so you don't have a claim. Well, in 2024, the Supreme Court said, hold on a minute. So this is a case involving a police officer who was transferred from a non-uniformed position to a uniformed one, which also affected some of her abilities for promotion. And it was a less favorable position, although it didn't necessarily affect her rank or her salary. And she said that happened because her supervisor wanted to replace her with a male employee. And the court didn't decide the case, but overruled the lower courts and said, no, that could be enough to show an adverse employment action. And so if you have had something happen to you at work, because this is pretty common, right? Like employers, particularly sophisticated ones, are smart enough to know not to directly come out and fire you, although that does happen. But, hey, they'll transfer you, make your life a little uncomfortable, but they don't necessarily take away your salary or your rank. And we recently just saw a case in the Fourth Circuit, which is a lot of the states in the Southeast, where a government employee had asked for remote work. That request was denied, and then after that, she had to take a lateral transfer, which again didn't affect her title necessarily or her salary, but was a much less favorable position. And the Fourth Circuit said, hey, that can be enough to assert a claim. So if you're in that situation, and it doesn't necessarily have to be a transfer, I think Muldrow can be interpreted in other ways that are favorable to employees. So if you're still at work, you've had something happen to you, but it's short of being fired or demoted, keep your eye on this case. If you're playing around with ChatGPT, which I think is not a bad idea, you should always have it reviewed by a lawyer. ChatGPT can get it wrong. But if you're doing your own research, if you want to know if you have a case, this could be a really important one. So Muldrow versus the city of St. Louis, keep your eye on that one.